Welcome to our representation of the United States versus 40 barrels and 20 kegs of Coca-Cola.
You won't shoot it at me though? Oh, wow.
Yo, bet.
Bet. Bet. Bet. Shut up, man.
Before we get into the actual video, we're going to be exploring some of the backstory regarding the actual Supreme Court case. So, in 1906, Harvey Washington Wiley was the first commissioner of the Food and Drug Administration when Congress passed the Pure Food and Drug Act. The FDA started prosecuting companies which were selling products with harmful components and companies which were making misleading claims about their products. In 1903, Coca-Cola had already started using spent coca leaves, which only carried trace amounts of cocaine, and had dropped the claim that it cured headaches. But still, it contained caffeine, and Wiley believed that even a small amount of caffeine in beverages were harmful to people, and he was worried that Coca-Cola was being consumed by children as young as 4 years old.
What a waste.
Ugh. Tastes like water. Caffeine? Caffeine? This is misbranded. It's with the Coca-Cola. I don't taste the Coca or the cola. This is absolutely dog shit. What's happening? Oh!
On March 13th, 1911, the government initiated the case under the 1906 Pure Food and Drug Act. It tried to force the Coca-Cola company to remove caffeine from Coca-Cola formula, believing that the product was adulterated and misbranded.
Coca-Cola is misbranded and adulterated. We cannot live for this!
Adulterated. The decision delivered by Justice Hughes states that the intent of the word added in the context of act did not exclude the ingredients of a formula sold under some fanciful name which would be distinctive. If any were found deleterious and was included to protect natural foodstuffs from prosecution because of constituent poisons rendered inert in their natural stage, such as fusel oil and liquor. Furthermore, it states that the introduction of caffeine in the later stages of syrup production made it an added ingredient. In any sense of the term, and removal of harmful ingredients, even vital to the identity of the product, did not constitute adulteration. Misbranded. Of the misbranding charges, the court held neither had the government proved that Coca-Cola was a descriptive name, nor had the Coca-Cola company proved it was not, making both of these assertions irrelevant. Thus, the court found that the issue of whether the product contained any Coca or Cola had not been settled.
Have you ever been depressed or sad or been bullied? Well, we can fix that with the Instant Beauty Maker. Here we can solve all your problems. Hi, my name's Jerry Smith, and today we'll be talking about the Instant Beauty Maker. The Instant Beauty Maker is a revolutionary new product. It can do anything. You can look at it, and you instantly feel uplifted in your day. You don't need coffee. You don't need anything to give you energy. The Instant Beauty Maker is your energy. This can cure cancer. This can cure the flu. This can cure AIDS. You don't need anything in life but the Instant Beauty Maker. Call this toll-free number right now, and you can get yours for $19.99. 1-800-256-0800. Do you understand? Good. The Instant Beauty Maker, $19.99. And if you call within the next 20 minutes, we'll send you another one for free. Instant Beauty Maker.
This is it, officer! This is the one! Do you know that your misbrand? Pick up.
Where were you? September 11th, 2001,
Where?
at 7:45 a.m.
Where? I know you're misbranded.
He knows. You don't have any Coca? You don't have any Cola?
Do you know that you also have caffeine inside of you?
I think he knows.
Maybe we should talk. You have caffeine inside of you. It sounds so sexual, but it's not, because it's a dangerous substance, and you're going to jail for this.
Do you know who this is? This is what you could be. This is basically what you're telling us that you are, because you're misbranded, you're adulterated, You taste like garbage. You don't have any Coca or cola. You're basically carbonated water with a ton of caffeine in it. You're Sprite. You're not Coca-Cola. You're trash. You're basic. You're anxious. You're failing all your classes.
I need you to calm down.
You know what? I'm not gonna calm down. You know why? Because you could be this, but this is what you actually are. You're trash. You're basic. You're false. You're dehydrated. You're failing all your classes. Look at you. Your skin's all red.
I'm sorry. Did you just repeat what you just said?
Yes, I did.
I really need you to calm down.
I'm trying to make a point that you're basic. It's basically he's basically Sprite. Whatever this thing is.
I'm the suspect.
This isn't a suspect to me. This is trash.
You know, frankly, I don't see anything wrong with this court case. It's not misbranded and it's not adulterated, and I don't appreciate you bringing this into my courtroom!
The case was returned to the lower court for retrial to determine the remaining factual matters. Justice McReynolds abstained. The case title naming an object 40 barrels and 20 kegs with Coca-Cola as defendant is an instance of jurisdiction against the thing. Rather than directly naming the Coca-Cola company as defendant, the food itself was the subject of the case, with the company only indirectly subject. In 1912, Coca-Cola eventually won the case, although later in 1916, worried that this ruling would debilitate the Pure Food and Drug Act, it appealed again in 1916 to the Supreme Court. This time, FDA had won, claiming caffeine to be toxic. Justice McReynolds abstained.
Coca-Cola then voluntarily reduced the amount of caffeine in its product and offered to pay all legal costs to settle and avoid further litigation. The settlement was accepted because Wiley had already resigned in 1912, and no one at the FDA was interested in continuing the pressure against Coca-Cola.
No. No, there's not. Just run, damn it. Look at this. Look at this. Look at this. Oh! Robert, I think there's gonna be a mistake. We're almost about to stop.
It's not a mistake.
No, it's a mistake.
It's not a mistake.
It's a mistake.
It's only a mistake if you regret it.
You're right. You're completely right. Oh!
I can't do it.
Okay, I think we're good. Robert, you're a dangerous man.
The things I do for love. Oh my God.
Robert, are you good, Robert?
You can't see out of this thing. What are you? What the hell? Action.
Yeah, you know, you're supposed to just
When
bet.
he does this, you're supposed to say bet.
Ready?
Right.
Okay, no, you gotta be like, bet.
You gotta
be. And action. Action. Okay, hold on. Sound is on. Go back. Go back. We're not done.
Is that the stuff?
That's it, officer. We were supposed to take it.
Come on, bro. I'm not gonna calm down. You know why? Because this is what you are. You're trash.
Oh,
Okay, go get Steve.
I'm recording.
I'm trying to think up of a word like this case is irrelevant.
You're irrelevant.
He's gonna get.
Honestly? You'll take a stab and I'll take a stab, so
Okay.
mine.
Action. Stab.
What are you doing?
I'm getting in the moment. Say something.
You're first.
Okay, what am I? Action.
Do you know that you're misbranded? Because, I mean, you're pretty damn misbranded. What do you gotta say for yourself?
Where were you the night of 9/11/2001? Let me reiterate. The morning of September 11th, 2001.
Do you know that you're misbranded?
I don't think he knows.
Do you know that you're misbranded? Because I know you're misbranded.
He knows.
Do you know that you have caffeine inside of you? Do you mind not dying right now?
Sorry.
Look over there.
You don't have any Coca. You don't have any cola. What are you? Are you water? With food coloring?
What are you talking about, bro?